Hello, everybody. Welcome to a new edition of Decent on Deals, the Exit Strategy Podcast. The whole goal of this podcast is, even though I'm in the business of selling businesses and I make money off selling businesses, I really want to educate the marketplace to make sure that people make the best decisions in their exits and they're best prepared to maximize the value and the outcome for themselves. And a lot of times that is done way before you ever meet with me. Today, I want to introduce you to my guest, Theresa Barbadoro from Baker Braverman. Excuse me, Baker Braverman Barbadoro. I always get the three B's mixed up, and I've known her for 10 years. She's a partner. I've done lots of work with her. She is, for ease of description, she's an outsourced general counsel. So she does all the stuff that needs to be taken care of with a business. I interact with her a lot through M&A over the years and through debt financing, but she can help with employment law. Anything that may come up that you need to understand legally to run your business, that's what she's an expert at. And the reason I want to have her on this show, in this podcast, is because over the years, we've dealt with lots of different issues. And a lot of them, if she was involved earlier on and could have helped prepare the business in a legal standpoint, and sometimes in a general business consultative standpoint, because she actually is a good business person in her own right, would help prevent some of these issues and would have saved them a lot of heartache and probably maximize their outcome, or maybe got their exit to be a little bit more smoother and more efficient and earlier. So without further ado, let me introduce you to Theresa Barbadoro. How are you?
I'm good, Greg. How are you?
Great.
Thank
And
you for having me on.
I loved and glad to have you on. Like, we hadn't worked together in a while, and we just, out of serendipity, I shouldn't say serendipity, you called me and introduced me to a client of yours. And it's a great client, great people. I love working with them, but they do have some wrinkles, just like almost every deal. Some of the wrinkles are preventable, some of them are not. And as we were talking about this scenario and other scenarios, you were telling me a lot of cool stories, and we were at a Christmas party, actually, just to be a little bit even more transparent. And a lot of our cool stories come out of what in exit planning we describe as the 4 Ds of business planning and exit and succession. Can you, Teresa, elaborate what one of the 4 Ds are?
So 4 Ds stand for death, disability, divorce, and disagreement. And
Just like
those,
ChatGPT says.
yeah, over the past 15, 20 years doing this, those are the 4 areas that come up that to your original point, if they are addressed early, when people are really happy to be working with each other, and when they are very reasonable about what should be done in case any of these 4 things happen, can really be addressed in a good shareholders agreement or a good operating agreement, so that when they do come up, you've already got a framework and a plan. Unfortunately, what tends to happen is they don't get to us until one of those 4 situations has happened, is now on the table, is happening, and they don't have them addressed in their founding documents, and that's where we tend to have a mess and have to help try to wade through it to ensure a smooth exit for one of the parties.
So, what you mentioned something about things like if that should be taken care of when everyone's happy and getting along. So I see this all the time where people get into a business and they know why they want to get into it, but they never think of how they might want to get out of it. Of the 4 Ds, which one creates the most work, or which one do you come across the most often when dealing and resolving these issues?
Yeah, I would say the answer is the same for which one comes up the most often and which one is the most difficult to deal with, and that is disagreement. Disagreement among the partners, whether it's about a specific trajectory of the company, meaning one wants to sell, one doesn't, or whether it's just that they can't get along anymore, they can't work together anymore. One party isn't pulling their weight, the other one becomes, upset about that. That's the one that comes up the most often, and if it's not addressed well in your operational documents, can be really difficult to deal with.
So how do you address this type of stuff in operation agreement? Because I've dealt with one where it wasn't really contentious, but it's clear the two owners let's try to keep it in a happy note for
Yeah.
because it can be very unhappy.
Yes.
Two owners are slightly different age, about 10 years apart. Business has been going great. They're both making good money. But one spouse retires and now they want to be retired and spend time traveling. But the other partner says, I don't want to keep paying you if you're not going to be working. I can't afford to buy you out. How
Yeah.
and I need you to do work or find a replacement for yourself. How do you work with so that's a situation that's not because they don't like each other, but their lives have changed. They're at different points in life, so now they're making different decisions. How do you help set that up at the beginning? How do you prevent that? And what are some of the things you could do to resolve that?
Yeah. So I think if you have a situation like you just described, which I think that one you might say this is probably inevitable down the line. And so when you are putting together the agreement between these two people to be partners, you might want to say, hey, what do you think about retirement or succession planning? Should we build in a way to make that work now? And that goes to the point where no money's on the table, the situation isn't in front of you. People are usually pretty reasonable about like, oh, okay, down the line, this would make sense. So let's come up with a formula for evaluation now, or let's agree with who's going to do a third-party evaluation for us, and let's come up with a payment structure for how that buyout's going to happen. That's one way to do it in a retirement scenario. Another is if they can't just figure out how to move the business forward, and this applies in disagreement a lot, is what's called a buy-sell provision, which a lot of people hear that language a lot, buy-sell, and not really sure what it means. I draft them as a provision in your agreement that either party at any time can elect to put the buy-sell into place. And the story I like to use here is if you have two kids and you have one piece of cake, no matter how you slice it, each kid's going to think they got the smaller piece of cake, right? They're going to be, this isn't fair. So how you fix that is you give one kid the knife and say, you make the cut, and the other kid, you get to pick which piece you want. You're pretty sure you're going to get a fair cut and people are going to feel like it's happy. So we do the same thing. One party can pick the price and say, this is what I believe the business is worth. And then the other party has, depending on your documents, 30 days or 60 days to decide whether they want to buy at that price or sell at that price. And it's an operative tool that ensures that if we can't get along, there is an exit strategy built in. People probably don't want that exit strategy. They probably want something else. But if you've got that as a tool to say, if we can't agree elsewise in some other fashion, this is the way it's going to happen. It's going to force the parties to the table to be reasonable and come up with a different solution. Otherwise, somebody's going to invoke the buy-sell and put forth a valuation price, and the other party's got to make a move, buy or sell at that price.
Oh, so that provision talking about I call it like the King Solomon.
Yeah. Yep.
So that's not part of the buy sell. That's before you get to the buy sell. Here's a way to determine that process.
It's a buy sell process that says you're either going to buy at that price or sell at that price, but this is the price, elect which one, and then the transaction moves forward. It's a contractual obligation in your documents that, and I always tell people when we're putting it together, this isn't the scenario you want. You don't want to use this.
Right.
But you have it as a default if you can't get anywhere else. And I get clients all the time that don't have provisions like this in their operating agreement or in their shareholders agreement. They can't get along. One wants to buy the other out, or either one is willing to buy out, but nobody can agree on anything. And they're just at a stalemate and they're stuck. And if we had that provision in their agreement, we can say, okay, we're invoking this. Here's the price, buy or sell, we're moving forward. And you would at least get the parties to sit at the table, or they're going to have to go with what the buy-sell provides. Absent that, you're really kind of stuck between these two people who don't get along anymore. The business is suffering because of it, or maybe it's not, but they're suffering because they're not happy anymore in their work environment. And they don't know what to do. And they say, how do we get out of this? And you got to try to use other ways to force them to sell to a third party or to force a deal between them, but that can take years. And your other option is trying to litigate if you think one party is doing things that are contrary to their fiduciary duties. But as we know, that's a long and painful process as well.
So as an attorney, you must love when they go to litigation because that means a lot of money if you like, is that a correct assumption?
No, I don't like it. That's my job is to keep clients out of litigation. And if I'm doing
You
my
gotta
job
be in there,
well,
throwing you a softball.
I know. If I'm doing my job well, I'm keeping clients out of litigation. Yeah, I'm fortunate in that my firm has great litigators, and a team of them, and so it's also really helpful for me when I'm working on a tricky scenario like that to consult the litigators and say, "What do you think? Can you explain to the clients what the litigation process would be if we have to go that way, or if we have to try to do a dissolution or something like that? What would that look like? How much time is it going to take? How much money is it going to take?" So that they can then make an educated decision of how they want to move forward. Yeah,
I
but
have a
it's
question on the
up in-
litigation,
yeah,
which we know we want to avoid, but just to kind of put context for people, have you ever been in a situation where the parties couldn't agree and they went to litigation and they both ended up in a better situation than if they followed a predetermined buy-sell?
no,
Has it
no.
ever been close?
In my experience, no, because if you're going to litigate, you're spending a ton of time and a ton of money. Litigation almost always devalues your company, because if a potential buyer looking at it knows that they are buying something that's got some problems between the parties, right? God forbid you go through the dissolution process, then you're really devaluing your company at that point. And so no, I think it would be a very rare occurrence that the parties would come up better through a litigation process than they would if they had just kind of planned for it beforehand.
Talk about the dissolution process. Like,
Mm.
why? Because I hear that threatened a lot. I mean, I at least once or twice a year I hear
Yep.
someone's like, "Well, I'll just dissolve this thing." And I think, well, let me hear your answer, and I'll give you my opinion. How does that process work, and why do you think it has such a negative impact on the ultimate value? Can I feel dumb asking you because I know it's an obvious question, but I want everyone to hear
Sure.
what does the process look like, and why does that really devalue the outcome for both parties or all parties?
Yeah. So the process itself can happen one of two ways. One is by agreement of the parties. That's all right. That's not, you're not gonna devalue as much then because you're making a calculated decision. All the parties agree to it. They figure out how to maximize the value of the assets they have. That you can do okay. Generally not as good as a ongoing concern business unless it's, heavy equipment business or something like that. But the other way is through the courts, and that requires you filing a court petition, asking a court to dissolve the company because of a deadlock among its members or shareholders. It's a high bar to be able to show that it's a deadlock. You have to really show that the business has been so impacted by the inability of its controlling members to get along, and that there's no alternative resolution available. It's a lengthy process. It goes
How
through,
long?
yep.
How
How
long do you think roughly?
um, Depending on what kind of motions are filed with it, if you file for dissolution, the other party may file and counterclaim for other things. So it's hard to put a number on it, but I'd say at least a year that you're going to go through that, and it's public record. So anybody looking to buy your business or pieces of your business or your inventory, your equipment is going to see that in a search in their diligence that it's going through dissolution. It's the same as any distressed asset, right? It's just going to drive your price down because they know that you have to sell at this point. You have to sell off your assets. It's going to be necessary to do as part of the dissolution. So people think, hey, well, I can get it at a bargain then.
What's interesting is that one of the perspectives I have on the dissolution, people always, I shouldn't say people, there's a common misconception is that when I talk to people, then when they talk about the value of their business, like, well, I have my fixed assets, I have my working capital, I have my cash, I have my employees and their know-how, I have my equipment, I have my trademarks, I have my goodwill. And by the way, goodwill is not an asset, it's what's left over after everything else. But they talk about all these things and they add them all up. And so they think, oh, if I go through dissolution, I'm going to get the same amount of money or more because each piece I might get overpaid for each piece. And quite honestly, I use this example, and you can tell me we agree, disagree. We have a company that makes widgets, and they say we have employees that know how to do it better than anybody, and they have the best equipment. And I said, can the equipment run by itself? No. I said, so if you don't have the employees, the equipment can't be run to make the widgets. And I said, no. I said, okay, so you can't, the machines aren't as valuable without the people. I said, if you get rid of the people, can the machines just run by themselves? No. I said, so the value of the people is contingent on the machine. So the two of them are relying on each other. And I said, then if we took your brand name off of the business and and sold it to someone else, how much would someone pay more because your name is on it versus someone else's name? And most people say nothing, unless you're Coca-Cola or McDonald's. Like most people say, no, there's not. Or the other thing I will tell them is they try to put their brand name and say my brand's worth so much. And I said, well, if it's worth so much, why aren't you selling more now? Because if it was worth much, you'd sell more.
Right.
So those are all the different things where people get misconceptions. Like my brand is worth more than everything else. I'm like, well, your brand is the totality of all the people and all the equipment and all the decisions you made in the past. It's not a separate asset when it comes to selling. And in dissolution, it doesn't mean as much. So
And
that's
unless you're purchasing equipment or something that is really like hard asset that can be evaluated and given a valuation and a number, maybe you'll get more than you thought for a specific thing like that. But like exactly what you're saying, it's how all the pieces combine to run
mhm.
a functional, profitable business. Um, it's certainly worth a lot more when you're giving it, when you're selling it to somebody who can step in and continue. People want to step in and continue to run it at the same method and the same profit margins that you were running it. That's what they're paying for. They're not paying for the pieces. They're paying for the operations as a whole.
I'm gonna go back to some of the stuff you talked about, the buy sell and the valuations and the just different process and some issues that I've seen come up. And it would actually, this also comes up in death and disability and divorce, which we can touch on, but it also comes up in disagreement. When you start your business, it's not worth that much.
Right.
When you get in your argument in disagreement, maybe it's 10, 20, 30 years down the road. And so $1 million business might be really worth 20. And to buy, when you say, hey, I'm going to buy out, I can pick a price and buy you out. And on day one, you say, I'd pay you $500,000 and you got to go. Well, 20 years down the road, I says, I have to give you 10 million.
Mm-hmm.
You know, some people may not be able to come up with the 10 million and they put them at a disadvantage, or both parties can't come up with the 10 million,
Yep.
but that's the right price to get half of it. How do
Yep.
you help them be able to take advantage of this buy sell, even though they might not be able to have the financial wherewithal in the future to do it?
Yeah. So I think that again, if you look at the business, and I recommend that for my clients that we meet once a year to kind of go through what's changed. If a lot of operating agreements and shareholder agreements will ask the parties yearly to come up with a valuation so that each year the valuation is set. That's a great practice to get into because then it makes it way less controversial when one of these things happens. I also typically build in a financing contingency into not contingency, but a financing plan into those documents. So the one we see a lot with respect to death of a shareholder or a member, you might have life insurance proceeds that are going to come in and be available to the company if have key man life insurance on your shareholders, so that the company pays the policy. Somebody dies, the money comes into the company can then use that money to fund the buyout of that party, which is a great way to do it. Alternatively, we can put in language that says the valuation is done by, X appraiser or by this method. And then the buying parties have, a 5-year promissory note set at, the applicable federal rate. And, that's how they're gonna, if they can't finance it themselves, they're getting outside credit facility. This is the way it's built in. So we try to make it so that it's something reasonable that the other party or parties could finance if they needed to.
You brought up the concept of like the buy sell in the situation of a death, and that's where I've seen it
Yep.
probably more often than in a disagreement. Um, why is it important to have a buy sell agreement with a partnership as when it comes in terms of a partner death or a shareholder death?
Yeah. 2 reasons. One is you are going into business with that person, not necessarily with their family and their estate. And you want to have a mechanism in there that if they die, same thing if you have a permanent disability situation, where you want to be able to give them the value or give their family the value, but you don't want them coming in as a decision maker now and as a shareholder that you have to run the business with. They might not know anything about the business. And so if you can structure it in a way with a death situation that you have a life insurance policy that is paid for by the company, it's a company expense. And that way, if that person passes away, it's very seamless. The money comes into the business does a valuation for the whatever method, and they pay out the family of the deceased member. And it's pretty simple, and it makes it a smooth process, and you don't have to worry about kind of, geez, I don't really want to negotiate with the estate over what it's worth. And, I want to make sure I'm good to them and help them out. And so it's a great way to do it. We've seen it with disability too. Sometimes you can carry like a disability policy that would, and plan out a disability scenario. Other ways you can just say if this person becomes permanently disabled such that they can no longer work in the business and their value to the business is being involved in the business, we're going to need to replace them. So we can come up with the same thing, like a way to determine what the value is at the time of the disability, and then a payment plan over time to pay them out is the same thing. And those are tough conversations to have when those situations arise, and the remaining shareholders never want to, usually aren't in a scenario where they want to make sure they're being good to the family or the individual who was their partner. And it just makes that so much easier when you've already got a set plan put in place, and you can say, this is what we all agreed on, this is how it's going to go. It's just a much better way to transition.
So I've seen the life insurance when there was a buy sell in place and there was a death, and I've seen a life insurance policy kick in the past.
Yep.
Can you use, and you talked about disability insurance cover for disability, can you use a life policy, or is there other financing mechanisms, like say it's a divorce, like you have a valuable business, but the only way to actually say the husband and wife are getting divorced, the wife owns the business, the husband needs to be paid out. The only way to pay it out is either to get a loan, but the business can't afford to take that big a loan, to take 50% of the business to give someone who's not going to be productive. Is there a way to use a life insurance policy to fund that type of a split, or are there other kind of mechanisms without having to go to a full sale?
Yeah, I don't think you'd probably be able to use a life insurance policy there, but you can put protective provisions in your agreement regarding divorce, saying that, the partners agree, or the parties agree, that if there's a divorce scenario, that no no interest can be awarded to the ex-spouse, only monetary value can be assigned, such that it's still part of the marital estate. It's going to be reviewed by, by the court or by the judge, and say, this is the value of this, but they'd have to find other assets to offset it, as opposed to awarding any interest in there. And that's what you want to make sure happens. Because again, you don't want an ex-spouse now having a vote in your in your company. So you want to put some provisions in that just provide that protection. And I've even seen more extreme provisions where they say, if someone's getting divorced, they become a non-voting shareholder or something like that. You can go really extreme. And I've also seen this in the context of succession planning as well, for the next generation, of how you want to make sure to protect those assets for if it's a family business like that too.
That's a good topic to bring up, the family succession.
Yep.
When it's two partners, it seems pretty simple, but one partner has 2 kids, the other partner has 4 kids. Not all of them are interested in the business. Some of them are. Not all of them are. Not just because your name is on the front of the building or your parents on it, doesn't mean you have the right skill sets for what that business needs. How do you use how would you help plan through operating agreements or any other tools to help with the generational succession in handling those issues?
It's a really good question, because it comes up a lot, I think. And I think when you're dealing with, especially if you have more than one family, like 2 partners, things like that. I've done structures where I'm thinking one in particular where you had 2 partners 50-50, and then they went down to the second generation, and we built it in so that what they didn't want was they wanted 50% to stay with each side, right? So we built in sort of family trusts that held the interest, and then there was a lot of strict rules in the family trust of how it would filter down to the next generation and then the generation after that. And it was really important to have that set up at the beginning, for the original 2 owners, but also that second generation that had already been in there and working, where now they saw some of how that played out with respect to certain of them had a much greater role in the business than others and may have a much higher skill set, and yet they're all being paid the same, and that can create a lot of dissension. And so with that third generation, how we set it up was they put into place like a compensation committee of outside advisors. So any relative that's going to work in the business has their employment structure run through the compensation committee, who decides what the appropriate wages should be. It's different from your ownership. You might have an ownership percentage through the trust, and that is what it is, but what you're going to be paid for your work as an employee has to run through the compensation committee to make sure that you're being compensated for what you actually bring to the table and not just because of your last name.
That's, I think, an awesome point you make. I think I've talked, one of my prior podcasts with Jeff Muir
Mhm.
is breaking apart the compensation you're entitled to as having your name on the front of the building versus what you actually are contributing. And Jeff and I, when it comes to selling a business and packaging in it, we've always said it's better to level set your operational compensation to what the market would bear so you can actually see what your true operating costs are. And just like you and I are working together in the same business, let's pretend we're related, even if we're not. Your role is worth $300,000. My role is worth $150,000. That doesn't mean that at the end of the year, when the profits are all divvied up, that you may end up with 600, I end up with 600, but you can normalize with family distributions, but the operating compensation should be tied to market. That like eliminates a lot of problems. And I also imagine when you have in estate type issues and you're working with this people inside the business and outside the business that are
Yep.
affected by the estate, like no, the compensation is the compensation, whether it's Teresa doing the job, Sally doing the job, Greg doing the job, Bill doing the job.
Yep.
That's what the pay is.
And that is a huge misconception that people have, is understanding the difference between their equity and their profit distribution as an equity piece and their compensation as an employee of the business. And that those are two different things. They're not, just because you are a 50% owner does not mean that your salary has to be the exact same as the other 50% owner if you do wildly different jobs. And so that is a piece that people miss all the time, and they think, well, I should get exactly what that person gets. And that is where you get, perceived disadvantage among people. And that's why it's really smart to set up something like a compensation committee. If you're dealing with, if you're going to have a fair number of employees that are relatives in the business, it also allows you to say, hey, I didn't make that decision. Like, we have an outside panel of advisors for a reason. So it's not you telling your daughter or your son, no, I don't think you should make that salary. Like, sorry, you're not worth that amount right now. It allows you to kind of not have to be the one doing that.
I think it's a great idea. And I've never heard of that option of creating an outside employment. Like, I mean, public companies have comp committees all the time. Never
Yeah.
really thought of it for a closely held family business. So it would be the way you see it structured, the way you've done it with your clients is that it's a completely independent group of advisors, or how did
Yeah, so the way I've structured it is with like it's not completely independent, meaning like they have a relationship with the business, so they understand the business. So like might be made up of their CPA, their like whoever their financial advisor is for the business. I've been on it as the attorney. And so usually what you're doing is submitting to them like, this is the job, this is the comparable, jobs in the market, and this is the salary that has been requested. These are the ranges, and you can help decide. And it's a delegation basically to an outside committee of advisors to help you make decisions there. Ultimately, at the end of the day, the board of directors, if it's a corporation like that, still has, the ability to say, we're not going to sign off on that if they don't like it. But it really gives you an outlet to have a voice of reason come in and say, this just doesn't make sense. Like, these are the right market ranges for this salary. These are the right market ranges for that salary. So you don't, and like, and that client for me that we kind of did this with the first time came out of their direct experience of the second generation coming in and seeing that happen and saying, listen, we don't want this to happen with the third generation, because now we're even talking even more people. And, some of them have MBAs and, could go get another job making $250 a year. And some of them, just don't have that type of skill set and experience. If they had to go work somewhere else, they maybe would make 100,000. So, it creates a disadvantage or disincentive for the people and the family members who do have the skill set to stay,
Mhm.
because they're really at a disadvantage if they were to go out in the market.
So it's common that family, when they have kids, that the genes don't split evenly and the skill sets aren't evenly matched to the market.
Yeah, it would be interesting to do a study on that, but.
I've seen it because I grew up in finances,
Mhm.
that I deal with a lot of financial people, and I deal with the family held businesses, and sometimes I deal with a finance person. The only reason they have the finance job is because they have the same last name and they don't trust anyone else to look at the business. And I'm like, yeah, I guess you can trust them. They have that checkbox. I said, but I don't know if they're competent or they're adding value. So it's interesting when you kind of do a true operational assessment of your family members. Like, how do you maximize their value and maximize the value of the company by putting them in the right spot?
Yeah, well, and Greg, I come at it from a really interesting angle because I work in a family business
Yeah,
myself. My
right.
dad was one of the founding partners of the firm, one of the three founding partners of the firm. I am now a partner in the firm. There's now 6 of us that are partners in the firm, and so I can understand some of that dynamic, personally, which I think is also really helpful in helping clients. Because
And you didn't get partnership. You weren't granted partnership just because of your name, and just because, like, I've known you for a while. When I first met you, you weren't a partner.
oh, no, no,
You
no,
had
and
to, you had to go through and earn it just like any other partner.
oh, yeah, absolutely. And I think what was also helpful for me is I didn't start my practice here. I went and worked at big firms in Europe and in California, and I worked in-house. And so by the time I came here, I already had, a good amount of outside experience. And um I've been here at the firm for about 15 years now, I think. And
Mhm.
I became a partner maybe 5 years ago. So yeah, it's but you understand sort of, and again, I think how they did it in here is, my dad wasn't part of those discussions, which he shouldn't have been. And so there's different ways you can do that. But it's when you have personal experience going through that, I think that's really helpful to bring to people.
This is a little off topic, but it's related to
Mm.
it's off topic to what we originally discussed, but it's on
Okay.
topic of what you just said.
Okay.
As a outside general counsel and as a good business advisor,
Mm.
which I know you are, because I've
Yep.
worked with you and seen you in action. How what would you recommend family businesses to have their kids work outside the business to learn other ways of doing business before they come back in? Or
Absolutely.
would you say, hey, start and just learn the way we do it? What do you see works best, and how would you recommend it?
I think ideally, if you can have other outside experience, I think that that's great. Because if you grow up only in one system and you only ever exposed to one way of doing things, it's just harder to have more flexibility. It's harder to see more opportunity and to see that there's different ways to come at the same problem. So I definitely think if you have the opportunity to work outside the business before you join a family business, I would highly recommend that. Um, I mean, there's some people who just know from go that like this is what I'm going to do. It's what I've always wanted to do, and there's no need for me to go anywhere else, and that's fine too if that's what you want to do and you're sure of it, and you don't see a need to go anywhere else. But I think any other experience can only add value.
Again, I'm still staying off topic here. So, did you decide that you wanted to go somewhere else before you came into the family business because you wanted to explore, or
Yeah.
did your dad say, "I would love you to come in here, but I want you to experience other things before you come back here"? How did that come about?
Never thought that I would be at Baker Braven and Barbadoro. So when I got out of law school, I wanted to travel.
You're a named partner now.
I wanted to travel. I wanted to. I mean, I started my legal career in Europe, in London, working for European companies that were doing business in the U.S. At a big U.S. firm, Latham and Watkins. So one of the, I mean, very different than this. One of the
Oh,
five
just Latham and Watkins, just one of
yeah,
those.
one of the 5 biggest firms in the world is where I started my legal career. So, and I did that for a couple years, and it was really interesting. I learned a lot, worked a lot,
Mm.
and then the 2008, 2009 when the market crashed, I moved back from Europe because we didn't have the business over there. I went to work in California. I had a stint in-house for Red Bull. I worked in-house as a general counsel for Red Bull, so I got that experience, which was also really interesting. But again, everything I'd done at that point with big companies, big banks, big companies. And what I realized was that I really enjoyed having more interaction with the actual business owners, being a part of the business, helping them formulate a plan, as opposed to sort of being, one of many advisors to a huge company. I really liked the sort of more personal relationship that you can have when you're advising smaller businesses, family businesses. Um, and so when I moved back to the Boston area, I started consulting a bit here with Warren Baker, the senior corporate partner. And I said, yeah, actually, I really like this. And that was 15 years ago, and I never left. So yeah, so it wasn't a thought for me really at all, but yeah, it just kind of ended up fitting into what I wanted after I had some other experiences.
I think what you're talking about your experience, I think it's important. This is more of an advertisement for you, and I wasn't planning on giving you an advertisement, but um, I deal with a lot of people like, well, we need to get the best attorney in the city. We gotta go to New York. And I like to tell people like you can get big law expertise, but you don't have to pay big law. You don't have to be a big law. Like you're a big law attorney. You just don't happen to work in big law anymore. And you and I have lots of colleagues and friends that we interact with same
Yep.
way. So there do not I would recommend to us for leverage people like Theresa and her firms. And there's other firms that similar
Yep.
situated, 3 to 10 partners, 10 to 30 attorneys
Yep.
and paralegals that they have the big law experience. You're not paying for the brand name and the multiple offices in 50 cities. So,
Right, and those big firms serve a purpose. If you are a huge multinational company, you need a firm like that that's got attorneys across, the world, and that can throw 25 attorneys on a deal to get it done in record speed. Like there's certainly a market for that and a need for that. But yeah, to echo your point, like, you know, I've done nothing but gain tremendous experience over my 15 years here,
Mhm.
and my billable rate is probably now maybe what it was when I was a second year attorney at Latham,
Wow. Wow.
because that's just the difference in what your market is and where you practice. So
So I'm gonna do another curveball. I know you can talk to this stuff, but it's not what we talked about in when I sent you the agenda.
it's all right,
So
bring it on.
you and I have done deals together. We're actually working on a deal now.
We are.
Um, you're indirectly a part of the deal as the GC, but what are some of the things like what aside from having the buy-sell agreement and the stuff in place, as you work through transactions, what is some of the stuff that you see kind of goes wrong in the middle of transaction, usually during diligence and as you're trying to draft an APA because it wasn't taken care of earlier? What are some key things that people should be aware of that, hey, if you're thinking of selling, you didn't do your operating agreement to start,
Yeah.
but you know you're going to start exiting in the next 3 to 5 years. What are some things they should start to think about now, even though they didn't do it at the beginning?
Clean up your corporate records. That's a big one. I had a transaction last year or the year before where at one point 10 years ago they had issued a bunch of warrants and things like that and never followed up with them, never got them cleaned up. And so you had a big transaction, 10 $12 million transaction that was being held up because they couldn't find two guys who had gotten warrants like however long ago. And so those little things can really hold you up. So clean up your corporate records. The other thing I would say is make sure that you have an idea of what you want to do after, if you're selling, because you and I both run into this, and I did one of these with your brother, with your twin brother, where it's not just an exit for how the business is going to sell, but then if you've been that business owner for a long time, what is your plan after? Do you want to stay and consult? Do you want to stay on as an employee? Do you want to take off into the sunset, and what is your plan for next? Because sometimes you get people who think that they're ready to sell, and then you go through the process and they don't actually really want to sell. Or they want to sell, but they thought they'd get to stay on as an employee for 5 years. Or, they don't want to have any obligations. They don't want to have to stick around at all and help transition. So I think that's the point people miss a lot in the
Mhm.
exit planning is not only how do we sell your business, but then what are you doing after that, and what do you want out of that? And that's a key point of how you structure your deal.
I like that you're talking about what you want afterwards, and do you want to take your cash and run, or do you want to have an ongoing
Mm.
an ongoing responsibility with the business? Just want to take some chips off the table. Um, how do you deal with with helping clients deal with that? Because like, for example, sometimes someone says, I want to get out of here. I just want to cash my check. As soon as it clears, I'm gone. Well, in order for you to do that, the business has to run completely without you. Do you have these conversations with business owners like, okay, we can do that, but right now the business is dependent on you. How do you help them start thinking about, let's get the business not dependent on you, the business to run without you, and you're just an advisor versus an operator? How do you deal with that?
Yeah, I think the first step is, and this is more on the sort of coaching and consulting side. It's not really the legal side. Like I said, a lot of what I do is business advising, um, is helping people mentally make that shift. If you're not running the show anymore, what are you doing? And a lot of people that have really successful businesses, the reason why they're so successful is because it's been their life. They've been so dedicated to it. And so to have to prepare them to make that mental shift that like this isn't going to be your life anymore and you don't get to make those decisions anymore. And so how do you want to set your business up? Because most of these people really care deeply about the employees and want them to succeed, want the business to continue. So how do you help them be ready for that? And that's a key angle sometimes because, people, I don't care, I'm selling, let the new owners figure it out in terms of making it run. But then you say, yeah, but you have a lot of employees here that you talk about and that I know you care about. So don't think of it as helping the new owners. Think about like, how do you want to set your employees up to be able to succeed without you? You need to help them figure that out.
Yeah, I
Um,
think that's a key point. I've dealt with, as you know, I used to do a lot more exit and succession versus transactional work when we first met.
mhm.
Um, and I found a lot of people, we used to use the phrase, if you say I versus we, your
Mhm.
business gets worse, less and less every time you say I. And I tell me if you agree or disagree, if you have a different approach to this. I always like to work with my clients or talk to my clients and say, you should take pride in that you trained people that can run this business without you. You
Yeah.
shouldn't want to, because I have people like they have so much pride in what they did and what they built, and they should because they built great companies,
Yeah.
but they want to make like this company can't live without me. And I'm like, okay, that means your business isn't worth as much because you have to be here.
Right.
Um, I try to shift the mindset like take the pride in I hired these people and I trained these people and I put these processes in place so it can run without me. And
Right.
it can because of what I did before.
Right.
So how do you I don't I think you agree with that, but you can elaborate and say
Yeah.
you
No,
disagree
I
and how you
absolutely
get that
agree.
mindset going.
Absolutely agree. And I do think that people, even if they have that mindset, oh, this doesn't run without me, if you kind of shift their focus to say, I know you care about these guys succeeding. You don't want them to lose their job 6 months after the sale happens. How do we help them get there? Focus on that over the next year. Focus on getting them to a place that's more helpful. Or, focus on downloading the information that you think you only have here into formats that will be helpful for them so that you can help them succeed. And that's also sometimes when you have that conversation about like, probably would be helpful for you to stay on as an advisor or as a contractor, and maybe we should build that into the structure. Because a lot of people do want to see it succeed. If they've built something, they have pride in that and they want to see that it is able to succeed.
This is the catch-all question because we're coming up against the clock. Is
Yeah.
there any topics that we thought we were going to discuss that I can't remember that I didn't ask you? Is there anything you want to talk about? Anything that one more point that you like to get across someone that's starting a business or exiting a business and they should
Hmm.
start planning now?
I think you just said it. If you're starting a business, you gotta, at the start is when you want to think about the possible exits. Um, and it's not too late. Here's the thing. If you're already 5, 10 years into a business and you're looking at it and you say, oh, geez, like we didn't address any of this in our operating agreement or in our shareholders agreement. If you and your partners are on good terms now, come in and sit down and talk about it and start planning it now. What you don't want to get is to have one of those 4D scenarios come up
Yeah.
and everybody can't get along because that's real money on the table now. When you're talking about, oh, if this happens in 5 years or if this happens in 3 years or in 10 years, people can think about that and they don't know if it's going to be which scenario if they're going to be the buyer or the seller. Then they don't know if they're going to be the one that has passed away and whose family they want taken care of. So it's really easy in those scenarios for everybody to be reasonable, right?
Mhm.
It's when it actually confronted with it and it's like this amount of money is coming from you, we're going to this person, or you have to do that. It's a lot harder to swallow. And so my key takeaway would be to be proactive, whether it's at the beginning of a business or in the middle, and you realize you haven't addressed these issues, to go ahead and be proactive and meet with someone to help you put it together.
So to summarize, if I said the best time to do all this stuff is the day you start the business and work with your partner. The next best is today.
Today.
The
Yeah.
worst case is when one of those 4Ds happen, because then it's very difficult.
Yep.
Well, this has been awesome. I knew it would be interesting, and I knew it would be fun and easy because you and I always have great conversations.
Always.
So there's lots of people going to hear this thing and say, wow, I wish I had an attorney that actually did more than just my legal documents, actually was an advisor. So I'm sure that some people want to talk to you. How could people, if they see this, can reach out to you and get in contact with you?
Oh, thanks very much. Always happy to talk to people. Especially, I love working with business owners, and especially if they have a relationship with you. Always, feel free to give me a call at the firm. You want me to just give the number, or it's
or just say, do you get, why don't we say go Baker Barbadoro,
Yep.
and what's your website, and then contact you through the website?
Yeah, sure. It's bbb-lawfirm.com. So,
and if my production manager does her job, which she always does, Maria is awesome, she'll put all this contact information at the very end so that you can reach out to Theresa. Well, Theresa, thank you so much for joining us. My
pleasure.
This is going to be very useful. I'm sure that if we had 2 hours, we could have filled it. If we had 3 hours, we could have filled it. So
then we would have got into some good stories, some Bruins, some other stuff. Would have been great.
Absolutely. So we'll have to do it. We revisit maybe in 6 months to a year. We'll have some story. We'll just do storytelling.
You got it.
So thank you so very much.
Absolutely. Thanks for having me.
The next time.
Take care.